Okay, so we're right at 2:30. I want to thank everyone for joining us today. I am Britt Burner of Burner Law Group, and I'm here today to discuss the role of trustee and executors. We're going to talk about what they are, how they get appointed to those positions, and what some of the things are that they have to be done. Importantly, I'd like to note that everything that we're talking about today is for educational purposes only and is not meant to be legal advice. The concepts that we are going to be discussing are going to vary greatly from person to person and from estate to estate. And so while we will be giving general concepts and ideas, it's really just meant to make you think about some things. And then it's very important that whether you are the individual who is thinking about your own estate and those that you're leaving behind to act on your behalf, or if you're currently or in the future will be serving as executor or administrator or trustee of someone else's estate, regardless, you need to receive your own legal advice in your specific situation. I'll also note that while we will speak about some things that are federal law, so they will apply across the country, for the most part, the concepts we'll be discussing today apply in New York State. And this is regarding to the New York State trust and estates laws that we abide by. And so if you are the person in charge of an estate in a different state, you would want to seek local advice on those issues. So all that being said, again, my name is Britt Burner, and let's talk a little bit about handling somebody's estate. So you may have heard these terms: administrator, executor, trustee. What do they mean? You may have even heard the term fiduciary. So what does that mean? Well, the fiduciary you can think of as the top layer. All of those other terms are examples of fiduciaries. The first time that we really pay attention to having a fiduciary in our lives is through a power of attorney. So if I have a power of attorney where I'm naming somebody to act as my agent, they are a fiduciary. They have a responsibility to me as the agent, as the principal under that power of attorney, to act in my best interest. That fiduciary responsibility carries through for an administrator, an executor, or a trustee as well. As one of those jobs, as someone who holds one of those jobs, you have a responsibility to the beneficiaries that you serve. So if it's the beneficiaries of the trust or the beneficiaries of an estate, that's where your loyalty holds. So the difference is really in how they're appointed. If there is no will, no trust, but there are assets in someone's sole name that have to be dealt with, then there's a process called administration. This is a process by which somebody can be appointed by the court to handle those assets and really distribute them under what we call the laws of intestacy, which are the laws by which nobody is named in your estate to receive assets, so your legal next of kin will receive those assets. So the administration proceeding will lead to an administrator being named to the estate, and that administrator's authority is put forth in letters of administration. And the court will give those letters of administration, and that's what allows the administrator to go and do all of those things we're going to talk about today. Similarly, if you have a last will and testament and you have assets in your sole name that need to pass through it, well, then you will go through a process called, or those you leave behind will go through a process called probate. And the probate process results in an executor being appointed, and that executor, their job is put forth in letters testamentary. So if you've ever had a situation where someone that you know has died and you've gone to the bank maybe to collect the checking account, and they said you can't have access to this account until you get letters testamentary, what they're really telling you is that you need to go through the probate process with the court so that it results in somebody being legally appointed to the estate as executor. Now, your will may say who you would like to be executor, but until that probate process is completed, that is merely a nomination. So that person is not appointed until the court officially appoints them. So that's the administrator and the executor. A trustee is an individual that's named to do all those same functions, but under a trust document. And there is no court involvement generally necessary, especially if you create an inter vivos trust or a living trust while you're alive. It will say who the beneficiary is after, I'm sorry, who the trustee is after your death. And that is who is in charge of handling the trust estate and the assets that are handled by that trust. Now, you may have a situation where you have a will that goes through probate, but that will says, if there's anything in my name, put it in my trust. In which case, let's say there was a bank account with $100,000 in it that never made it into your trust while you were alive and is hanging out there when you die, your executor or your nominated executor would bring a probate proceeding. At the end of that proceeding, they would be given letters testamentary, appointing them as executor, and then follow the terms of the will, which states that the assets should be poured into the trust, at which point the trustee takes over, which may or may not be the same person as was named the executor of the will. So who can serve in these positions? It must be a US citizen, a US person. So we need somebody who has a social security number, who could open a bank account. It's not really practical to have somebody outside of the United States because of the work that has to be done. A lot of times we recommend that there be somebody joint if there is someone who's living outside of the US, even if they're not a citizen. If you are a green card holder, you have to have a New York State resident serve jointly with that individual. Now, in some other states, and for example, someone once told me that in Florida, you have to be a Florida resident in order to serve as executor of a Florida state. That's not the case in New York. There is no court requirement. There might be a preference for somebody in New York, but if somebody is nominated and they live out of state, that is not going to be an issue. So the very first thing to do before you're appointed, before anything, is to make sure that there's enough copies of the death certificate. Rule of thumb, 10 death certificates. However, if you know that you're pre-planning your funeral and you're planning for your own estate, or if you're planning someone else's funeral because you're going to handle their estate upon their death, it's important that you know how many accounts or assets there are that will have to be collected. Because if that individual had 15 bank accounts at 15 different banks, well, then you'll need a death certificate for each of those accounts. And so while 10 is the rule of thumb to make sure there's enough, you want to really pay attention to the specific circumstance. You can always get more death certificates later on. It's just much easier to get them at the time of death when they're originally issued by the funeral home that is handling the final remains of this individual. And so that's our best estimate is to get 10. So then, probate or administration, like I said, probate is when there's assets in somebody's sole name with no beneficiary that has a last will and testament. But if someone has those assets with no beneficiary listed on them and no joint owner, but they don't have a will, then it's going to be an administration proceeding. So the next step for someone who is the nominated executor or who's handling an estate of someone who doesn't have a will would be to file a petition with the court for probate or for administration. And that's a public proceeding. So all that information becomes public record. You could go look up the last will and testament of any will that's gone through probate. You can see the address of the executor, the address of the individual who passed, the address of certain beneficiaries that are named. So it's a very public proceeding. And if you've ever been the executor of an estate, you know that a few weeks after that probate petition is filed, you start getting a lot of mail about closing out an estate, throwing out junk, selling the apartment. I've served as executor multiple times, and that happens every time. And they want to sell my apartment, which isn't even, the client may have lived in a rental, but they still see that information and just start sending out information. So don't be surprised if that starts to happen. When you go through this proceeding, the legal next of kin must be notified. Now, we could go into a whole issue about when you create a will, who gets noticed, why you should have a will, why you should have a trust. But rather than spend a lot of time on that today, what I want to point out is that if you have a will, the legal next of kin have to be notified. If you have a spouse and children, that's who gets notified. If you don't have a spouse and you only have children, they're all notified. Even if you're disinheriting one of them, they are notified. If you don't have a spouse or children, then it's do you have grandchildren? If you don't, then we look to see if you have parents. That's the next in line. Then if you don't have parents, do you have siblings, et cetera, and it goes out. And so when we can't locate who the next of kin are, or if we're disinheriting one of those next of kin, that's where probate can get very expensive. And the job of an executor can be very difficult because they have to defend the fact that that will should be followed because that's what they were entrusted to do. And so the proponent of the will, the executor who's saying this is a valid will and I should be appointed executor, has to fight that fight. And so that's a reason why many people want to avoid the court process of probate or administration, because they want to avoid that fight with other individuals. Okay, so I'm just looking to see if there's questions. I'm going to try and take questions as we go along, but don't worry if I don't get to them as we go through. I will make sure to get through the questions at the end of the program. So once somebody has been appointed as executor or administrator, or without the process, once they are the trustee that is taking over the trust, then we look to see if they have to set a bond. So a bond is security. So we mostly hear of bonds in the context of somebody's arrested and they are arraigned and then it's bond or bail, right? Are they out on bail? What is that? That's security. That's making sure that they come back to court for their next court date while they're being let out of prison, let out of jail, while they wait for their hearing. And so that bond is set to make sure that they're going to come back. It's the same thing for an estate. A bond is something that will make sure that the executor, the trustee, the administrator is doing what's right by the beneficiaries. And if something goes wrong, it is monetary insurance that can make sure that those beneficiaries get paid. Now, many times we waive the requirement of a bond in a will or in a trust because it has a premium, it has a cost to it. And if somebody is naming a trusted family member as their trustee or executor, they often don't want the estate to bear the cost of the bond because of that extra cost to the estate. And whether or not the bond will be issued and how high the premium will depend on the size of the estate, and it will also depend on the background of the individual that's being named as fiduciary. So if you have an executor who maybe 20 years ago had some financial trouble, bankruptcy, et cetera, it may be difficult for them to be bonded, even though they've cleared that up and things have gotten much better. So you really want to pay attention to whether or not that person is bondable if you want there to be a bond set on the estate. You would then notify creditors. Credit card companies, other than creditors, you notify banks. If there's a mortgage, if somebody, often we want to freeze the credits, we want to notify the credit reporting agencies that there is that someone is deceased. The Social Security Administration is usually notified by the funeral home when the death certificate is issued. So it's not usually necessary to contact the Social Security Administration, but that is something that is notified through the death certificate process. You want to notify these things, especially with the credit report ratings, you want to make sure there's no identity fraud where the social security number of the deceased person is used to do anything inappropriate going forward. Then if letters have issued to the estate, or if it's a trust where the trustee is either taking over or just continuing on their job as trustee, a tax ID number has to be assigned. So a federal tax identification number for the estate or for the trust will be assigned at the death of the individual. Then all assets are to be collected. Now, again, these are only assets if you have an executor or administrator that we're talking about. These are assets in the sole name of the deceased person that have no beneficiary. So if there's a checking account with nobody else on it, but there's an IRA with a beneficiary, then the executor or administrator are only taking control of that checking account. And as for a trustee, they are taking control of the assets in the name of the trust. So if that checking account is in the individual's sole name and the retirement account has a beneficiary, but there's a condo or a house in the name of the trust, well, then the trustee is only in charge of that condo or house unless, as I described before, the estate is probated or administered and the assets pour into the trust. And if that's the case, then the trustee will be in charge of that bank account as well. But that retirement account with the beneficiary, the executor and the trustee are not in charge of that account. However, what they are in charge of in terms of that account is taking the last required minimum distribution for the deceased person. Let's say this individual who died is over 72 years old. That's the age at which we now have to take required minimum distributions on our tax deferred retirement accounts. And they did not take, before they died in that year, the required minimum distribution. So for example, if you die in August, and usually you took your required minimum distribution in November because you liked it to continue to grow throughout the course of the year and took the distribution at the end, well, then the person in charge of the estate would have to take that last required minimum distribution before the asset was distributed out to the beneficiaries. You would need to open up a bank account in the name of the trust. So if I'm collecting a $100,000 checking account that's in somebody's individual name, well, then there needs to be an account opened. The executor would use the tax ID number and open an estate checking account and move the assets into there. And that's where all the business of the estate is done. For a trustee, they're still operating under the trust bank accounts. You need to clean out the primary residence and any secondary residence. What is to be done with the tangible personal property? So very often in an estate, the assets are either say that they will be distributed to a certain individual. So all my paintings and collectibles will be distributed to my best friend, in which case that should be done, collected, inventoried, and eventually handed over. Or they might say all of the assets are to be given to my trustee or to my executor to distribute according to their discretion. Or it might say you can't do this in a will, but you can in a trust say I have a tangible personal property memorandum that states how my tangible property would be distributed, and then the trustee would distribute according to that document. So you have to go back to the source document, the will or the trust, to see how that personal property should be handled. I've also had estates that say all of my personal property should be sold and the money that comes from that should be distributed according to the rest of my estate and the rest of my document. So that's a very important thing to pay attention to. If you are the executor or the trustee and you are entrusted to handle artwork that could have value to it or other assets that could have value to it, be it monetary value or personal value, you would want to make sure that you are properly packing and storing those items so that you are not in a situation where you're being held responsible for something being destroyed or harmed because it wasn't properly being stored by the estate. As you're going through the home, you want to make sure that you're retaining things like birth certificate, social security card, marriage license, divorce decree. If you see any of these important documents, you will want to hold on to those. Things like income tax returns, bank statements, other records, for those, you want to hold on to those, generally speaking, for 7 years. That's our rule of thumb for how long you should hold on to those types of documents. You want to make sure that items are appraised for the date of death value. So if there is a home, be it an apartment, a second home, any assets, any artwork, anything like that, you want to make sure there's a date of death value. One, so if we have a capital gains tax issue at some point, we have a marker for what the asset was worth at date of death. And two, sometimes there's formulas in documents. Some documents say, give my daughter the painting in my living room, but give my son a monetary equivalent. Well, then you'll need an appraisal to determine what that monetary value is. You also want to make sure, as someone who's in charge of this estate, that you maintain proper insurance coverage, whether it's homeowners insurance, renters insurance, car insurance, if the car still has license plate tags on, or insurance over this personal property that I'm talking about that has to be stored and could be at risk of getting ruined if not done properly. I'm going to pause now and see if there's any questions that we can answer related to these issues. Someone asked, if you move to another state and you're the executor of a will in New York, will there be an issue? We're going to talk a little bit about bank accounts, which we have discussed a little bit. You can still serve as executor or trustee if you are out of state, but you will need to open up a New York State estate account. And so it's not a large roadblock, but it will likely require a return to New York for that individual. But otherwise, they'll be having to go into the property and either dissolve of all the assets, sell the property, get it ready to be re-rented, whatever it may be. Those are the types of things, but it should not be that big of a deal. Someone asked if I touch on the POA. I only briefly talked about the power of attorney at the beginning to state that a power of attorney document is the first time that we often use a fiduciary. Fiduciary being someone who has a responsibility and handles affairs for us, but the power of attorney dies along with the individual. So for the conversation today, we're talking about who will be handling an estate after the individual's death, in which case it goes to the administrator, executor, or trustee. Then we have another question. Can a trustee arrange for an aid through Medicaid's CDPAT program? I would say that would be something that the power of attorney agent would be able to handle for an individual. The risk to a non-family member acting as trustee. I would say that the non-family member trustee, that might be a situation where you would want a bond on the estate. Many like having a non-family member trustee because by doing so, it takes some of the emotion out of the situation. So if tensions are high between the children or the siblings or whoever is being left behind these assets, sometimes having a non-family member involved is very helpful. I wouldn't call it a risk, but there are also commissions to executors or trustees. And so if there's a preference to not allow the assets to go out of the family as commissions, then that would be one downside to having a non-family member acting. There's a question about whether or not I could be whether or not somebody could be a beneficiary and the trustee administrator. And yes, you definitely can be, and quite often people are. We often find that it is a family member, the spouse, who's also a beneficiary who serves to handle the estate, or it's the child who is also one of the beneficiaries, or children. You can have co-executors or co-trustees or co-administrators. So yes, you can serve as both the trustee administrator and be a beneficiary. There's a question about keeping assets, keeping documents for 7 years, and whether or not those need to be in paper or electronic. I would say electronic is perfectly fine as long as after your death, there's someone who is able to access those electronic records. So whether it's someone having the password to your computer, or if you have a Dropbox or something along that line. So I would want to make sure that you have someone who's able to access those records. We often put into our documents, both for a trustee of a trust or the executor of a will, that that individual would have access to what we call digital assets, and that includes these online, your online presence. And so I would say if they have access to your online presence and you give them the passwords and such, then they can access those documents, and that would be perfectly fine. There's a question about agent form in New York. I'm not sure what that individual is asking, so if you'd like to write in a clarification, I'd be happy to answer. So I'll keep moving on. So we talked about those first steps to be taken, about cleaning out the residence and preserving the assets. I want to add in about preserving the assets. You want to make sure, if you are serving as executor or trustee, that you are not holding on to assets that will decrease in value. So I'll give you an example. And this gets very specialized based on the estate. So I'll give it the example two ways. One is someone holds on to a stock. They bought it for $1. When they die, it's worth $100. And it's one share of stock. And that was obviously a very large capital gain. But it gets stepped up to the date of death value. So if you sold it while you were alive and it went up by $99, then you're going to pay a capital gains tax. Whereas if you passed on after your death, the inheritor gets it at your $100 date of death value, right? I talked about getting date of death values on homes and other assets. We have date of death values for what a stock was worth on the date of that individual's death. And if then the executor cashes that in, then that asset will go into the estate and be handed over to the beneficiaries. The executor runs the risk that if they don't cash that in and they hold on to that stock and it plummets 3 months later, what responsibility does that executor have to the fact that they held on to that stock and it plummeted? And so this is a great example of why, if you're an executor or a trustee or an administrator, you need to be advised on your situation by a financial advisor, an accountant, and a lawyer, because they need to explain to you the importance or the likelihood that there will be a loss in value for that stock. Now, on the flip side, I've had clients who've said, we have stock, it's from a company that my great-grandfather worked at, and it's not about the monetary value. It's that we want to have this asset, which is a stock in a company that's important to our family, and we want that to pass on as this stock to the next generation. And so in that case, you would not cash in that. You would give it as what we call an in-kind distribution to the beneficiary, where the beneficiary is not getting the monetary value of that stock. stock, they're getting the actual stock certificate or the actual stock share. And so each estate is going to be different, but it's something you need to pay attention to if you are the fiduciary of an estate that has assets, marketable securities, etc. in it. If there are assets that have joint owners or beneficiaries, again, that is not going to be something that the administrator or the trustee is dealing with, except, as I said, if they have to take that last required minimum distribution for the year of death, and if they have to file an inventory, which I'm going to talk about in a few minutes. So now I want to talk a little bit about estate tax returns and portability. So let's say somebody dies in 2021 and they have a spouse. And this year, for federal tax purposes, federal estate tax exemptions say that I can die and leave behind $11.7 million, and there would be no federal estate tax. If I leave above that, a tax will be imposed on my estate. And that includes both gifts I've given during my lifetime that were above the annual gift limit per year, as well as gifts at my death. And if I give assets to my spouse, there are no estate taxes regardless of how large. So let's just say I leave all my assets to my spouse and we don't file a gift tax return. But then what happens if when my spouse dies, my spouse's estate is now over the estate tax limit? Well, then there's going to be taxes due at that point in time. So very often we tell someone who's the executor of a estate or a trustee of a trust that they should be filing a gift tax return, we call it a 706, so that they can preserve portability. What is portability? So if I have $5 million and I leave it to my spouse, or I leave it to wherever, and we file an estate tax return and I check the box for portability, then my unused amount, I have 6.7 that I didn't use. That's what we call my DSUE, my deceased spousal unused exclusion amount. So the DSUE is then carried over. So when my spouse dies, they have their own estate tax exemption, which will be based on whatever it is in the year in which they die, plus they'll have the balance of mine. That's $6.7 million of exemption that they'll have the benefit of and that the beneficiaries will have the benefit of. And so filing an estate tax return, even though there was not any estate tax owed on the estate, becomes incredibly important to the future planning for the spouse. So as the executor or the trustee who may or may not be that spouse, they need to not only know what the plan is going forward, know what the full range of the assets are, but they may need to file that estate tax return timely. It needs to be done on time, or else the spouse loses that benefit. So it's a very big responsibility for the executor or the trustee or the administrator of the estate. It's also important if you are the executor or the trustee or the administrator of the estate that you're aware of any unused exemption that the decedent that you're assisting, that you're the trustee or executor for, did they have any unused exemption from their prior deceased spouse? And how will that affect their own estate? And so that's a really important thing for you to know as the fiduciary of the estate is there any exemption left over that I get to use to benefit these beneficiaries that I have a responsibility to? And so portability is something that's really important to pay attention, especially as you get into those larger estates. The other thing I'll point out about portability is right now, the estate tax exemption is 11.7 million. Under the current law, so the law that's actually in place right now, that will sunset. And in 2026, that number is going to go back down to probably around 6 million. It's indexed for inflation, so the exact number isn't out. But for those who die starting January 1st of 2026, that exemption amount is going to go down to about 6 million. So if I die this year and my estate files for portability, but my spouse dies after 2026, my spouse gets a huge benefit, because not only do they have their own exemption, they've got this big exemption left over because I died while the number was really high, while it was 11.7 million. So paying attention, especially right now. I'll also point out that we don't know what will happen in Washington in terms of legislating to lower the estate tax exemption sooner than 2026 or to a lower number even. And so filing for that unused exemption could end up being a huge benefit if we do see legislation that brings it down even lower. Moving on now, we talk about paying the debts. So the executor, the administrator, the trustee has to pay all the debts of the estate. One of the really common questions I get asked is, am I personally responsible to pay any of the debts of the estate? And the answer is no. To the extent that there are debts, they only have to be fulfilled by estate assets. And so if somebody dies and they have no money, they just have a lot of debt, you will not be responsible for their debt. And the beneficiaries will not be responsible for their debt because we don't inherit the debt of another person. If it is an insolvent estate, there's a judicial proceeding that can be filed for that purpose. Funeral bills and administration expenses take priority as claims against an estate. There's Medicaid, which is a super creditor. So a lot of times if we're doing Medicaid planning, we actually make it so that there is no probate or administration, because then Medicaid does not have a lien of which they're a super creditor. If the assets are in a trust, they don't have the right for estate recovery, unless of course it's a first party supplemental needs trust, but that's a separate issue. The creditor period is 7 months long. So basically you don't want to distribute out assets as executor or trustee before that 7 months is up, because if a creditor has 7 months to come forward, you don't want to be in a position where you've given out the assets of the estate and you have nothing left to pay back the valid creditor claim. And so that's very important that you not jump the gun. I know a lot of people want to close this up, move on, get past it, but holding on to the assets through that creditor period is going to be really vital to making sure you're doing a sufficient job as the administrator executor of the estate. You can reject a claim if you don't think it's valid. I've had executors come in and say, this is for a hospital bill. It was not submitted to insurance while they were still alive. It needs to be submitted to insurance. That is not a valid claim of the estate. They submitted insurance and it's covered. So you don't have to pay all the claims that come in, but you have to determine whether or not they are a valid claim. And there's a court proceeding that can happen if a creditor wants to say that you're incorrectly rejecting a claim. If you know about a debt, you can't ignore it. So this is where personal liability can come in. If I'm the executor of an estate and I know that the decedent, the person who died, owed a certain creditor a sum of money, and I move forward with the estate and I don't inform that creditor that the person died and then they can submit a claim, then I can be held liable personally because I knew that claim existed and I willfully ignored it. So you don't want to be ignoring claims that you know to exist as actual claims. You have to file the final income tax return. So this is not just the estate tax return that we talked about for portability purposes, but also the final return for any income received from the deceased person in the year that they died. So that's another job for the administrator, executor, fiduciary of the estate. You have to do an accounting. So for an executor and administrator, it's really important that you keep records from the point at which you're appointed. For a trustee, it's equally as important, but I really want to stress the fact that especially if you are trustee while the individual is still living, and then you stay on as trustee after death, you need to maintain records from the first appointment as trustee. It is not just for your service after death. So if you are appointed a fiduciary in any capacity, you want to keep records. Similar to how we tell you to keep 7 years of records after someone dies, we find that across the board, banking institutions don't have records beyond 7 years. So if you became trustee 10 years ago, you will need to do an accounting of those entire 10 years. And so you will need to have the records to do that accounting in your own files. So it's very important that you keep accurate records of all of the estate and trust assets. Now, the accounting can be informal or formal. If there is a few bank accounts and the trustee or the executor can show the assets went into the estate account, they show a spreadsheet of what bills were paid and then what's left and how it's distributed, that might be enough for many beneficiaries. Whereas if there has to be a judicial accounting, either because the beneficiaries are contesting, in certain cases, if there's a charity named as a beneficiary, anytime a charity is named, the Attorney General represents the charity in the proceeding. And so at certain times, the Attorney General, we need to do a formal judicial accounting, not always, but sometimes it's advisable. Then there's a form, and it's a formal pleading with the surrogates court that has to be submitted. But once that accounting is approved, either informally by the beneficiaries or formally through the court, then the assets can be distributed to the beneficiaries. You should never, as a fiduciary, distribute assets to beneficiaries without getting receipt and releases. A receipt and release is a document that should describe the fact that the individual was appointed to the estate as fiduciary, and then further point out that the accounting was given and that it was approved, and that the beneficiary will not hold the trustee or the other fiduciary responsible for any issues moving forward. As the fiduciary of the estate, you want this release so that this is not hanging over your head ongoing, and that this beneficiary, before they received their assets, said that they had no claim against you and no issue with the way that you did your job. So the receipt and release is incredibly important, and that it be prepared by an attorney who understands what needs to go into it, because sometimes I've seen a receipt and release that's prepared, but it doesn't really follow the rules and have enough information to allow the trustee to be released from future liability. And that's really important for the fiduciary. You might be distributing assets outright to a beneficiary with just a check, or maybe to a further trust. It might be a trust for the benefit of a child. It could be a special needs trust. It could be a marital trust or a credit shelter trust for estate tax planning purposes for the surviving spouse. So there needs to be coordination in terms of who's the trustee of that ongoing trust. Is it the same individual? Is it somebody else? Do you have proper releases in that situation? New tax ID numbers for these new trusts that are being created at the time of the individual's death. And then you need to change the ownership of certain assets. So obviously, if it's just, I give 100% of my estate to so-and-so individual outright, you're writing a check, you're giving it to them, and they're depositing it. But what if it's a property or a piece of art that has a title to it, or a car? Well, then you need to change the car title or sign a deed over to the beneficiary or to the beneficiary trust. You need to actually change the title of that asset in whatever way it has to be done. So I know there was a question about fees, and that was the last thing I was going to review. It will be on a case-by-case basis, as many things are. but there are statutory fees. So there are fees that there's a statute that sets them out. So for example, if you're the executor as appointed through probate, there is a formula and you would receive 5% of the first $100,000, 4% of the next $200,000, and 3% of the next $700,000. So roughly that breaks out as an executor. If there's $500,000 in assets, the executor would get about $19,000 in commissions. If you have a trustee, it's a little different because a trustee gets commissions in two different ways. One, they would get annual commissions, which is set out by statute. And then at the termination of the trust, they get 1%. So that same set of assets, $500,000 in assets, might, as a trustee, you may only get, $14,000 or $15,000 as opposed to the $19,000 as executor. But a lot of the commissions depend on exactly how the commissions are given in the document. Do they say they're statutory, or is there another method or formula put in? And also, what type of assets are in the trust? Is it a property? Is the property being sold? And so a lot of that plays into it. But I wanted to give you somewhat of an idea of what the commissions look like. Certainly, if you have an attorney who's acting as your executor or as your trustee, the attorney will often receive commissions, but also have a law firm prepare the legal work for the estate, just like a private individual would. And therefore, the law firm may get fees as the law firm and also as the fiduciary of the estate. I'm going to go back to the questions now. So what would happen to a person's estate if she has no legal documents explaining who gets what? So that is when the assets go through the administration process, and the administration process would be through the laws of intestacy, which would mean that your legal next of kin would receive your assets. So if you have a spouse and children, then your spouse would get the first $50,000 and half of the remainder of your assets, and your children would share the other half. If you have just a spouse, they would receive 100% of your estate. If you have children, they would share 100% of your estate. And then if you don't have a spouse and children, that's when it starts to get to grandchildren, then your parents, your siblings, and it would go down the line. But at any line at which an individual is found, that's where the 100% of the assets would go. The agent form for disposition. Okay, so this is about the agent to control disposition of remains form. This is a form that we often sign with clients to talk about how they want their bodily remains to be distributed or be handled. So very often, if we have clients who wish to be cremated, for example, we will have them sign this form stating that they wish to be cremated and stating who the individual is that they would like to be in charge of making sure that they are cremated. We also recommend, especially if somebody's concerned that their wishes won't be followed out or that somebody won't know what their wishes are, we recommend that people prepay or pre-plan their funeral so that they can make aware their agent that they're naming that everything's already been set and this is the number to call. And so that's a very common document that we have people sign. Otherwise, it is the next of kin who is responsible for making sure that the remains are handled properly. And if you have multiple children, say, who disagree on what should happen with your remains, it could lead to a delay in the final process. So be it burial or cremation, as they figure out exactly what's going to happen. So if you have strong feelings for how you would like your remains to be handled, we recommend that you put that in a form and name an agent to follow those wishes. If there's an overseas property, we recommend that you speak with an attorney in that other country. Every country is different. This person specifically is asking, should you set up a trust in that place also? Not every country recognizes trusts. I had a client who had assets in Spain, and we had long talks with the attorney in Spain where we were basically told that Spain doesn't recognize trusts. And so they had to do a different estate plan with those assets because that was not an option over in Spain. And so that's something that you will need to check in whatever locality you're talking about. The next question, if a stock is transferred, that's transferred to a Medicaid asset protection trust while the person's alive, does the basis step up upon transfer? Good question. The answer is yes. So if that stock I was talking about before, I bought it at $1, then it's worth $100, and I transfer it to a Medicaid asset protection trust, that is what we call a grantor trust. And so I am the grantor, I am the creator. It is my asset for income and estate tax purposes. And upon my death, that asset gets a step up in basis, meaning that if it's worth $100 at the date of my death, that is how my beneficiary inherits it. And if they turn around and cash it in right away, there will be no capital gains tax because there will be seen to be no gain, because from my date of death to sale, there was no gain. There's a question about commissions, but we went through those, so I think those were already answered. If the deceased bank account has your name on it, does it pass directly to you? Do you have immediate access because your name is on it? So it depends exactly how your name is on it, but if that is a true joint ownership bank account, then yes, you should have direct and immediate access. We often find that people say their name is on an account, but when the other individual dies, it comes to light that they were on the account as a power of attorney and not actually as a joint owner. So you want to make sure that you're on as a joint owner so that you have true access to the account after the other individual dies. Okay, so if there's an IRA with a beneficiary who distributes the assets in the IRA, likewise for a joint account, does the surviving account owner get the remaining assets in the joint account? So if there's, oh, I understand. So if there's an IRA with a beneficiary, it is that beneficiary's responsibility to contact the institution and to state that the individual is deceased and that they believe themselves to be a beneficiary. Usually what will happen is the company will say that they will send out notification to the beneficiaries listed on file. This is why it's very important that if your beneficiaries move or change their phone number or their address, that you identify that and notify the banking institutions where they're named as beneficiary. They do usually have their social security number, but it would be a lot easier to find them if they had updated contact information. So you want to make sure. Many times if somebody is the trustee or the executor of a trust, because they're the holder of the death certificates, sometimes they will, on behalf of the beneficiaries, reach out and notify the institution that the individual has died so that the beneficiaries can properly be notified. In terms of the surviving account owner in this question, again, if it's truly a joint account, then the joint account holder will receive the assets as long as it's joint right of survivorship. Some accounts are what we call tenants in common accounts or properties. If something is tenants in common, that means that we each own 50%, meaning that when I die, my 50% goes according to my estate plan, and the other individual's 50% goes according to their estate plan. So if an account is joint with right of survivorship, it will go to the joint owner. But if it's tenants in common, it will not. It will go according to the estate plan. So the receipt and release, there's a question about what assets it's needed for. Any assets that the fiduciary is in control of. So if there's an IRA that I don't have control of because it has a beneficiary named and I'm just the executor or I'm just the trustee, then no, I don't need a receipt and release for that asset. But I would need a receipt and release for any other asset that came into my possession and that I controlled prior to passing it on to the beneficiary. So if the executor is also beneficiary, must he be paid fees on the basis of the formula? So the beneficiary can waive receiving commissions as executor or trustee. Also, when I create my documents, I can say that my beneficiary doesn't receive commissions when they serve. I have had clients who, instead of giving commissions because they didn't like the formula or they didn't think it was enough money, they gave a monetary sum. And they said something along the lines of, I gave $50,000 to my nephew if he serves as my executor or if he serves as my trustee. And then they waived and said that commissions should not be paid. It's just going to depend on how the document is written and what the individual wants to do upon the time that commissions are to be calculated. More questions about commissions that I've answered. Can all the trustees' fees be collected at the termination instead of annually? Yes, unless there's something in the document that specifically states that this cannot be done. So there's a question, is it better to change title for the house to the children while alive or put it into a trust? This falls into the category of something that you should definitely get personalized advice on. What I'll say is that we often don't recommend putting a home into the name of someone else while you're still alive. It can have very negative tax consequences. When I was talking about capital gains tax for the stocks, that applies for real property as well. So you want to make sure there could also be a loss of certain real estate tax benefits. So if you have property tax exemptions for being over a certain age or for being a veteran, you would lose those property tax exemptions if it's not in your name anymore, the residence. And we also don't like people to give away their house because they might want it while they're still alive or might want to sell it and take the money. So for all of those reasons, I would say to get personalized advice, but we don't generally recommend just turning the house over to a child unless there's a specific reason to do it. So if 5 beneficiaries are named in investment accounts or bank accounts, how is the distribution process? How long? That is something that's not done, again, through the trustee or the executor. So it just really depends on the institution that holds the account and how quickly they notify the beneficiaries and how quickly the beneficiaries respond. I know in some estates, I've had an account that one beneficiary takes their distribution because they got their paperwork together, but the other was very slow. Same with the life insurance, where it was a 50-50 beneficiary and one just didn't fill out the paperwork very quickly. So the other got their assets much quicker. Does a true joint checking account get frozen when the person dies? No, that does not. If it's truly joint, then it will go to the joint owner and it will not be frozen. However, I will point out that a joint safe deposit box will, in almost all cases, be frozen regardless of if the joint owner is still living. And so we caution people as to what they're putting in safe deposit boxes and if they really need it or not, because they may not need it. It might be more of a headache than it's worth. There's a question, debts and bills are paid from trust assets. So assuming that all of the assets flow through the trust and the trustee, and usually there's a language in a trust that says so, but yes, the debts and bills are normally paid off the top before that accounting is done and before the receipt and releases are signed and the assets are distributed out. There's also a time where if somebody has some assets going through probate and some assets in a trust, there needs to be coordination between the trustee and the executor, especially if they're two different people, to make sure that they're not double paying asset debts, and also that they're coordinating who's paying what, because you don't want to double pay and you also don't want to skip paying a creditor. So it's very important that they coordinate between the two if they are different. So if an account is not joint, but there's a transfer on death signed, will that serve the same purpose? So it's not exactly the same. It's transfer on death is more like a beneficiary designation. So the institution holding the account would be notified that the individual died, and then the transfer on death beneficiary would be notified by that institution as to the steps that they need to follow to collect that account. And again, the trustee or the executor does not have to notify that institution, but they can do so if they want to. Are funeral expenses paid by the trust? Sometimes. It depends on the type of trust. So many times, if it's supplemental needs trust, a first party supplemental needs trust that somebody is looking to protect their assets and they put it in there for that purpose, then funeral expenses are not usually paid by the trust. However, for any other, a revocable trust or a different trust, it might be possible to pay them. It really just matters how quickly the funds are going to be available. And again, this is why we often recommend that people pre-plan and prepay for their funeral so that they don't have to worry about where those assets are going to come from at the time. I think those are all of the questions that were asked. If there are any other questions, I'll hold on for a few minutes, but for anyone who has to jump off, thank you so much for joining today. This is a really great conversation. As always, please feel free to check into our website or to our other webinars that are coming up, and we'd be happy to provide you with more information and education. Have a great day. And like I said, I'll wait around for a few minutes to see if there are any additional questions. Thank you. I see some people have raised their hand. If you could just type your question into the Q&A, that would be great. Okay, I think that might be it. I don't see any. Oh, here's some extras. Someone asked if you can listen to the recording. We will be putting this up on our website. Okay, great. Thank you, everyone. I hope that you have a great day.